Hello, it's me again. I wanted to talk to you about something that is very dear to me. Again, Seattle. But I wanted to talk to you about the landlord-tenant laws in Washington. It says here, find out key laws every Washington landlord and tenant needs to know. Both landlords and tenants should be able to deal with many legal questions and problems without a lawyer once they understand the basics of state law. Now, that's where it gets a little tricky because the state has worded the law in such a way that unless you have studied in the field of law, you'll not understand the wording. It's not so much the words as how the words are said. Like, I talk to people about the Ninth Amendment all the time. And then I also talk about the federal definition of motor vehicle, and it has the word contrivance. Most people haven't the slightest idea what that word means. They just think it is a large word, and it doesn't really, they don't understand what it means. They think it's put in there just because it sounds big, but contrivance has a particular definition, the same as the definitions and the laws that are written for the tenants of the state of Washington. It says here, both the landlords and the tenants should be able to deal with many legal questions without a lawyer once they understand the basics of state law. This overview of key landlord-tenant laws in Washington will get you started. Now, I'm going to regulate this video to just this. Required landlord disclosure in Washington. Under Washington law, landlords must disclose specific information to tenants, usually in the lease or rental agreement, which that's basic. There's things that the landlords have to put in their lease, or they have to let the tenants know when they're going in. Usually in the lease or rental agreement, such as whether any fees are refundable and the identity of anyone authorized to act on the landlord's behalf and provide educational material on mold. For a full list, see Washington's required landlord's disclosure. I'll do that at another time. I won't do that here. Washington's security deposit limits and returns. Washington state law does not limit how much a landlord can charge for a security deposit. However, it does limit when it must be returned within 14 days after a tenant moves out, and sets other restrictions on deposits. See Washington security deposits, limits, and deadlines, and I'll talk about that in another video as well. For more on that subject, I'll discuss that. Small claims lawsuits in Washington. Tenants can sue landlords in small claims court for the return of their deposit up to a dollar amount of $5,000. And also it says here, see filing a security deposit lawsuit in Washington Small Claims Court for more advice for tenants filing suit. Landlords defending a security deposit lawsuit should check out Washington Landlord's Guide to Security Deposit Disputes in Small Claims Court. Now, Washington late fees and other rent rules. Now, before I get into that, I wanted to just say this. I understand under normal circumstances, when it's all sunny and there's a nice breeze blowing, the state of Washington is supposed to look out for the residents of the state of Washington. My question is, why, if the state is going to make all these regulations, why is there a need for towns and cities to have mayors and lieutenant mayors? And why is it important to have a city council? You got the state. Now, Washington late fees and other rent rules. State law regulates several rent-related issues, including late and bounced check fees, the amount of notice at least 30 days in Washington, landlords must give tenants to raise the rent, and how much time? 3 days in Washington. They have at least 30 days of notice. State law regulates several rent-related issues, including late and bounced check fees. The amount of notice, at least 30 days in Washington. You got to give them at least 30 days. Landlords must give tenants to raise the rent, and how much time? 3 days in Washington. A tenant has to pay rent or move before a landlord can file an eviction. It has to be at least 3 days before they can file. Any landlord that's not a Mafia Don landlord, and you know who I'm talking about. You know those types, the ones that only care about the money, they don't care about the tenants, the ones that are unwilling to give you a chance when you're in a bind. Now, I get it. You can't allow everybody to be late, and you can't allow everybody to bounce a check, because there's no way you could keep the apartment open. There's no way you could take care of the necessities of running the apartment. I totally get it. I do. I'm not totally against people making money. I'm just against people making money when innocent people get hurt. That's what I'm against. Now, Washington rights to withhold rent, and tenants' rights to withhold rent in the state of Washington. Tenants may withhold rent or exercise the right to repair and deduct if landlord fails to take care of important repairs. If you're in an apartment and the landlord's not fixing what needs to be fixed, you got a hole in the roof and it's leaking, or you've got faulty plumbing, you can say, I'm not paying you until you fix this. Such as a broken heater also. Washington tenants' rights to withhold rent or repair and deduct. Now, you can go and read that, which I may do that in another video, along with the other ideas. But upon holding the rent, you have to put that in escrow, which means that you have to put that money aside for whenever you have to. You're still paying the rent. You're just not giving it to the landlord. Washington termination and eviction rules. State law specifies when and how a landlord may terminate a tenancy. State law regulates how the city or town, how the landlords in that city or town may terminate a tenancy. For example, a landlord may give a Washington holdover tenant an additional quit notice that gives the tenant 3 days to move out before the landlord can file an eviction. See state laws on unconditional quit terminations. Now, I'm going to click on that because I'm curious to see what that says. Now, I'm going to open this up in another window. and we shall see what that says. The state laws on unconditional quit terminations. Now, before I do that, I'm going to look up what unconditional quit termination stand for. Unconditional quit notice. Unconditional quit notices. I don't like Google, not very much. You put in a query to look up something, and it takes you to 40 million other things that you don't want to know about. Pay rent or quit notices are typically used when the tenant has not paid the rent. Unconditional quit notices are the harshest of all. They order the tenant to vacate the premises with no chance to pay the rent or correct a lease or rental agreement violation. Which means that, like where I live at now, we have a no alcohol policy on the property. If you get caught drinking or you get caught with alcohol, they can terminate you overnight. You have 24 hours to vacate the property because you have broken that part of your lease. Now, you can say that that's not legal. They can't just toss you out like that. Well, yes, they can. They put that in the lease and you sign your name on the dotted line, which means that when you sign your name on the dotted line, you are giving them permission that if they catch you drinking, they can put you out within 24 hours notice. Now, here where I live at, it's possible that the landlord may ask you to go to treatment. They'll hold your apartment while you're in treatment, and then you come back and you can have your apartment again. They've done that in the past. Now, it's pay or quit. Now, an unconditional quit is not the same as pay or quit. Either you pay or you get out. If you choose not to pay, you get out. An unconditional quit notice means that they're not giving you a chance to pay. They're telling you, we don't want you here anymore. You caused us too much trouble. You're out of here. That's that. Now, unconditional quit terminations, we've talked about that. The state rules on when a landlord can order a tenant to move out on short notice. Usually short notice is 30 days. Now, shorter notice can be 3 days, a week, it can be 2 weeks. An unconditional termination notice orders a tenant to move out within a short period of time, or in some cases, immediately. They'll call the sheriff on your butt and have you out of there in a split second. And they'll toss your stuff out onto the curb. That is because they want to get you out of there. Sometimes people get an unconditional quit notice, an unconditional termination letter to get out immediately, not because they're not paying the rent. They don't have to show any proof on why. All they have to do is just say that you did something to cause you to get terminated, because they want your apartment, because they can get an extra $2,000 out of that apartment if they couldn't get that while you were there. Now, all states allow landlords to use unconditional quit notices when a tenant has repeatedly violated a lease clause. Now, that's all states, except for the state of Washington. You really don't have to have a reason, and you've got absolutely no recourse. You cannot sue because of it. You cannot take the landlord to court on that. That's what I understand. You cannot take the landlord to court. Now, when a tenant has repeatedly violated a lease clause, has substantially damaged the rental unit, is dealing drugs, or for other specified reasons and unspecified, depending on what state you're in. Here are state rules on when a landlord can use an unconditional quick termination notice and how much time the landlord must give the tenant to vacate the rental unit before the landlord can file an eviction lawsuit. Now, when you go to court on an eviction lawsuit, 9 times out of 10, the judge will rule in the favor of the landlord. The reason is because they want the landlords to feel comfortable. Now, there is those instances where the judge will rule in the tenant's favor if the landlord is found to be a Mafia Don slum landlord. Now, the city council got pissed off at me for using that phrase, Mafia Don Landlord. I stand by that. That is a phrase that I use to talk about unscrupulous landlords that are in it just for the money, and they could give a crap less about the tenants that are renting from them. Let's see here. Here are state rules on when a landlord can use an unconditional quit termination notice and how much time the landlord must give the tenant to vacate the rental unit before the landlord can file an eviction lawsuit. As noted, the amount of time may vary in various circumstances. For additional details, see your state statute. The citation is provided here, and you can visit the Library of Congress's legal research site for links to state statutes. Now, every state's got a different statute. They don't all get in a huddle and say, this is the way we're going to do it. It's not like the states are like the 5 mob bosses where they all get together and they say, hey, we need to get this under control. You got people over here and people over there creating problems. And it's interfering with business. We got to get on the same page, or we got to close the book permanently. Capiche? You ain't got people doing that. Every state operates differently. The following termination rules may be tempered in domestic violence situations, which means that if, say, your apartment gets destroyed due to a domestic violence dispute, say your girlfriend is tearing up the place because she's mad at you, or the boyfriend or the husband or the boyfriend is destroying the place because he's upset with his girl, wife doing the same thing, or husband, and vice versa. It says here, state statute, time to move out before the landlord can file for eviction. State, this is, we're going to go down to the state of Washington, and we'll explain what, let me get down to where Washington is at. Washington, rev.code and subsection 59.12.030. 3 days you got to move out before landlord can file an eviction. You've got 3 days. Holdover, serious damage to property, carrying on unlawful business, maintaining nuisances, or gang-related activity. Those are unconditional quit notices that can be used for those reasons. And unconditional quit notices, they're saying that the unconditional quit notices can be used for, sometimes I hate my phone, can be used for holdovers, serious damage to property. That's when there's no domestic violence going on, or you're not being robbed and somebody, you're just doing damage, serious damage to the property because you just don't give a crap. Carrying on an unlawful business like working out of your house as a business, you're making it into a red light district, you're selling drugs, you're performing medical procedures, that sort of stuff. Maintaining a nuisance, which means that the police are always being called on you because you're too loud. Your music's up really loud. Now, I like to listen to music. I like it kind of loud sometimes. But I don't like it to be so loud that the neighbor complains. Now, if you're in a gang and say you're with the East Side, West Side double blood Crips, and you're trying to take over the North Side, South Side territory, and you're running your operations out of your apartment, unconditional quit notice. Now, West Virginia, for the move out, can be immediate. Other states like Wisconsin gives you 14 days for month-to-month tenants. 14 days, tenants with a lease of less than 1 year or a year-to-year tenant. 5 days for all tenants. So that's that. Now here, featured landlord and tenant law firms, so that's where I live at. So there we go for that. Now, that's for the quit notice. Now, they give you an unconditional. If you get a pay or quit, that means that you got so many days to pay your rent or evict yourself. If you're just being lazy and you haven't paid the rent and you're supposed to be out looking for a job or you got no income coming in now, you can't just lay up in your apartment and hope the manager or hope the landlord will be okay with that. They can give you an unconditional quit notice for various reasons. Now, in the state of Washington, they don't have to have a reason. They can do it just because, and you got no way to protect your ass. Landlord access to rental properties, tenant protections against retaliation in other states and the law, state laws in Washington. Several other landlord-tenant laws in Washington affect both property owners and renters, including restrictions on landlords' right to access rental properties. Washington landlords must provide 2 days' notice to entry or 1 day to show the property to actual or prospective tenants or buyers. Now, if you're moving out under good circumstances, you found another apartment that you like better, you and the tenant, you and the landlord are on good speaking terms, you paid your rent faithfully, you've not caused any trouble, but you're just moving because you found a better place. Maybe it's a little bit bigger. Or in some cases, people are downsizing because they think they've got way too much apartment. The landlord in any place in Washington has to give 2 days notice if they're coming in to fix an appliance. Or 2 days notice if they need to come in and check something. 2 days. They got to give you 2 days notice. And you've got to know about the 2 days notice. In most states, where I live at, they give you 24 hours notice, regardless of whether you know about it or not, as long as there's a notice that they've given in your apartment or they've slid on your door or tacked onto your door that says, oh, we're going to come in, the plumber's coming in to fix your toilet, then he'll come in. But he can't just walk in without giving you notice ahead of time. Now, if it's going to be put up for rent, you'll still be living there. You still got your stuff. You haven't packed up yet. The landlord can bring people in with a day's notice. That gives you a chance to kind of straighten up, make it look presentable for the prospective tenants that are going to move in. Now here it says, tenant protections against landlord retaliation for tenant exercising a legal right, such as complaining about an unsafe living condition. It says, see Seattle state laws prohibiting landlords' retaliations. Now, the landlord can't just harass you for no reason. If the landlord doesn't want to fix something in the apartment that's hazardous to you, say there's mold in your windowsills, that needs to get taken care of. You could be breathing that in and you get sick. Say you've got a leaky faucet that needs to be fixed, or your toilet's not working, needs to be replaced or fixed. The landlord can't come at you cockeyed just because you complained about it. Special protections for tenants who are victims of domestic violence. See Washington state laws affecting tenants in domestic violence situations. Now, tenants who are victims of domestic violence, you have special protections that the state gives to you. That means the landlord can't just toss you out because you're not at fault here. Procedures for how landlords must handle abandoned property left behind by the tenants and fair use and fair housing rights. Discrimination is also prohibited by federal and often local laws. They can't discriminate against you, but actually fair housing rights, if you can't afford the apartment and there's no apartment available to you because you're on SSI and you're making $755 a month, and they tell you that you have to have 3 times what the rent costs in payola coming in each month to live there, that's going against fair housing rights. You're being discriminated against because you're poor. Section of no cite for detail. Okay. Now, housing discrimination. I'm going to look up the housing discrimination and put that in probably tomorrow's video. Where to find Washington landlord-tenant statutes. Now, if you're curious where to look for these, and you know somebody who understands them enough to be able to explain them to you as they're being read, that would be great. If you want to read the text of a law itself, such as state security deposit rules, you'll find citations in many of the articles and charts, including the state landlord-tenant laws. If you get on Google, you can type that term in, state landlord-tenant laws, Washington State, and it'll bring it up. Go to if you want to access the statutes, you can go to Washington Laws and Legal Information section of this website, which is www.nollo.com. You can get a link to your state's laws. Now, if you want to browse through Washington landlord and tenant laws, you can go to the state statutes at Washington rev.code ANN dot subsection 59.04.010 to 59.18.912. You can search the table of contents there. And the landlord-tenant statutes, or you don't know the exact statute number, you can enter a keyword that is likely to be in it, such as non-payment of rent. In addition to accessing the laws via NOLA's website, Washington statutes are available in many public libraries and in most law libraries that are open to the public. If I have repeated this, I apologize. My video got cut off, so I'm going to add this to that video really quick. Local ordinances affecting Washington landlords and tenants. Here it says that that cities and counties often pass local ordinances such as health and safety standards, federal tenant regulations. With most landlords, tenants will primarily be concerned with state law in Washington. Okay. Now, I plan on talking about federal landlord-tenant laws and regulations tomorrow. Today, I am just dealing with this. Some of your rights, some of the things that the states have tied your hands on. They've allowed landlords to run rampant. I'm not saying all landlords are bad, so please don't give all landlords a bad rap. You'll know a bad landlord when you bump into them. They'll be hard to miss. Now, there's a lot of other places you can go, but for right now, that's all that I wanted to talk to you about in this video. This has been All Things Considered, because I consider all things.